By the end of this video, you will find out why Judge Glanville says Young Thug's representation would have been useless at the ex parte meeting. So stick around until the end. Also, like and subscribe to our channel.
Just bear with me, y'all. If you haven't seen this video yet, we're going to look at Glanville explaining his actions. Okay? Then we're going to go back and we're going to look at the transcript, which we, with a lot of work, put into our AI voices. If y'all haven't seen that yet, check it out. But we'll be watching it today. And then we're going to try to draw some conclusions about this in particular. My take on it, though, as of now, is Glanville's perspective is not I did the right thing. His perspective is I didn't do anything wrong. And that's two different things. I did what's right. I did not do something wrong. Okay? So I'm going to play this real quick, y'all. Bear with me.
As Judge Glanville gears up for his recusal hearing, we reviewed his most recent court appearance.
That's not my voice,
to glean some
way.
insight as to how he will defend himself against charges of judicial misconduct. Glanville actually laid out his entire defense, and we are going to analyze it for you. Glanville's defense consists of at least 3 parts: adhering to Rule 2.9 of the Georgia Code of Judicial Conduct, conducting the ex parte meeting due to an emergency relating to a threat to Woody Copeland's life, and asserting that what happened at the meeting will not have an effect on the trial. Stay with us as we explore each of these prongs of Glanville's defense in more detail.
So, L. Fallon, you said a judge should never have to explain themselves. This is a public trial. Glanville is laying out his defense that he's going to give, that at least the way I see it is he's laying out his defense that he's going to give in front of the neutral judge who's going to have to conduct his recusal hearing.
1. Glanville claims that the meeting was not prohibited because it did not deal with any substantive matter and did not give one side a substantive or tactical advantage.
Okay, so what does that mean? Glanville is going to make the case that, look, I didn't do anything wrong because what I did do did not benefit one side over the other. Okay? Again, I didn't do anything. He's not saying I did what was right. That's not the point. He's saying, hey, what I did didn't help this side. Now, y'all might disagree with this, okay? I'm not defending and saying I agree with Glanville's take on it. I'm just explaining his take, okay? So his take is this. This ex parte meeting did not help the prosecution, and it didn't hurt the defense. Therefore, no harm, no foul. That's what he's saying here.
This would be in accordance with Georgia Code for Judicial Conduct, Rule 2.9.
As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part.
Jamie, I'm not saying this did not damage the defense. I'm saying that Glanville is claiming it didn't damage the defense. I don't know when you say if you're referring to me or if you're kind of referring to him. I'm simply explaining his perspective, okay? So I don't want people to get upset with me. I'm telling you what Glanville is saying. I actually think that there are certain things in the transcript which seem like it could be helping the prosecution or hurting the defense. And you could even argue that the entire reason for taking a prosecution witness who is refusing to testify and then helping the prosecution convince that person to testify, that obviously helps the prosecution. I mean, that's the whole point. But that's me. That's my perspective. So what I'm trying to do here, though, is I'm trying to help us understand Glanville's argument. This is the argument he's going to use, I believe, because he said this publicly now, right? He's on TV with this. Glanville is going to use this argument when he goes to the hearing, okay?
Where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication.
Okay, so y'all, I'm not gonna make y'all sit through this whole thing. So that's the key point. Rule 2.9 says, look, if you don't benefit them and you don't hurt them more or less, you at least you're safe from that perspective. So that's his first point. His first point is, I didn't hurt YSL. I did not help the prosecution. So if we jump briefly, if I can find this, if we jump briefly to, I'm going to jump briefly to the last of the three, okay? Because these two really go together. He didn't help the prosecution is his contention. He did not hurt the defense is his contention. Why? How can he say that, right? Because we saw the transcript and we know that the whole reason that he's even doing this is to help the prosecution convince Woody to testify, right? Like, that's the whole point. That's the whole point. So how can he say that one side's not helped and one side's not hurt? Thank you, Rashad. Appreciate that. I hope y'all feel like this is good content, y'all. We're trying. So, but this is how he can say that, okay? Now, am I saying I agree with him? No. But I'm explaining, really, he's explaining himself. We're just packaging his explanation in an easy to understand format for the people. Okay, so what we just did is just repackage this long rambling kind of blah, 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 with a bunch of case citations and stuff, which we're going to get into one case, which is in the middle, which is the point number 2. He has all these case citations and whatnot. I actually looked these cases up to see what they say, right? But point number 1, Rule 2.9 lets me have this ex parte meeting as long as I don't help one side and I don't hurt another side, okay? That's going to go with point number 3, no effect. So let's listen.
States that the defendant's presence would not have affected the outcome of the ex parte meeting. Glanville cited Bruner versus State, which relates to the defendant's right to be present at all critical stages of the trial proceedings.
Okay, y'all, this is Bruner versus State. The defense has a right to be present at all critical stages of the trial. Now, these are legal terms, y'all. Critical stage of the trial. So, what Steele is going to... Now, I don't want to say anybody's first name before I get corrected. I'm just going to say last name, y'all. What Steele is arguing is, hey, this ex parte meeting was a critical stage of the trial. We have a witness who wanted to plead the 5th, and we have a prosecution who wants to compel the witness to testify. This is a critical stage. We should have been there. Okay? That's what Steele wants to argue. Now, what Glanville is going to argue is, he's subtly going to say that this was not a critical stage of the trial based on Bruner. Bruner is a case in which the judges dealt with this sort of situation. And Glanville's going to say it's not a critical stage. How do we know that? Because it had no effect. Because, and as you're going to see, the defense's presence would have been useless. You're going to hear him say useless. Now, he's very defeated, y'all. Personal interpretation. To me, Glanville's demeanor, okay? So I'm not going to say he's defeated. So I take that back. Glanville's demeanor looks defeated in this video, okay? So he's kind of, he's down, he's not teach you to do this in the military. He's not doing that. He's kind of down here with it, okay? So is this body language showing he doesn't even believe himself? Is he tired? Is he just fed up? We don't know. So he's kind of mumbling it. But if you think about it, saying to somebody that excuse the squeaky chair, y'all. Saying to somebody that in your own trial, your presence in this meeting would have been useless. Like, we want to put you in jail, in prison. Hey, we want to put you in prison. How long? As long as we possibly can. All right, well, I don't want that to happen. Yeah, and we're going to have a meeting with this witness. I'd like to be there. nah, your presence would be useless. Like, hold up. You trying to put me in prison, right? Like, am I the person that you trying to put in prison? You can't tell me, like, you trying to get this guy to testify against me, right? Like, you want him to testify against me. Yes, we do. And he's saying he's not going to do that. Yes, he is. And you're going to pull him aside and try to get him to testify against me. Correct. All right, well, I want to be there. Like, I have a constitutional right to be there. Nah, your presence would be useless here. Like, okay. So anyway, listen up. Again, Glanville is going to say it in a kind of downtrodden way, but listen to how he puts it.
Glanville concludes that his court did not violate this right because no party gained a tactical advantage during the meeting, and the proceedings were released as a transcript. Glanville seems to indicate that the defendant's presence at the meeting would have been useless because the meeting was about questions of law and legal arguments.
The court's also considered Bruner versus the state. That's 302 Georgia at 6, and this relates to the right to be present and what is defined as a critical stage and under the Sixth Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings.
Okay, so here we have critical stages. So, still, this meeting was critical, was a critical stage. Glanville, CYAing, y'all know what that means. CYing his A, okay? C'ing and Y'ing his A. No, he's saying it was not a critical stage.
Body within the constitutional right of the courts to a criminal defendant's right to be present, see and hear all the proceedings which were had against him on trial before the court. Violations of this due process right are presumed prejudicial, absent a waiver by defendant requiring a trial. However,
listen,
there were no violation of Bruner's right to be present. The right to be present attaches to any stage of a criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure.
Okay, so would the defendant's presence have contributed to the outcome, the fairness of the outcome?
Versus the state, 274 Georgia, 110, pinpoint 111.
Listen up.
Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where a defendant's presence would be useless or benefit.
Useless. So Glanville is claiming, and this is what I want y'all to analyze for yourself. Would thugs, would steals, would all the defendants' interests being represented there at the ex parte meeting with Woody, would that have been useless? So Glanville is going to argue that, and remember, Glanville in a sense is going to be, he's on trial at this point, right? Not for jail, not for prison, for recusal. But I mean, it's a hearing. It's a mini trial. I'm calling it a trial, y'all. Glanville's going to have to argue, but judge. So now he's the judge. He's going to be arguing to the judge. Judge, if they had been there, it wouldn't have made a difference. Why? He's about to say why. Why would it have not made a difference? L. Fallon, without attending, how can he deem uselessness? He's about to tell you the reason. Okay, just listen up. I'm gonna point it out.
A shadow. And under the Georgia Constitution, defendant who is represented by counsel need not be present for portions of the trial that involve questions of law and consist of essentially legal argument about which the defendant presumably has no knowledge.
Okay, L. Fallon, that's your answer. Again, Glanville is not speaking very he's not enunciating, and he's not military man with it. He's not speaking with his chest, right? Like he's down, okay? But if you notice, what did he say? He said that this meeting, he insinuated, okay, by citing this, he's insinuating that the meeting was about questions of law and legal definitions. What does that mean, y'all? what Glanville is saying without using the words is, all we were doing was explaining immunity to Woody. That's what he's saying. I'm going to say it again. Glanville's contention, Glanville's assertion. Now, I shouldn't say it's assertion because he didn't actually come out and say it. Glanville's insinuation is this, based on the first and the third of the 3 points we pointed out. Now we're going to go to the third in a moment. On the first point, Rule 2.9 allows me to have these meetings as long as I don't help one side or hurt the other side. Okay, bam, done. 3, Bruner allows me to have this meeting as long as we're not at a critical stage, and we weren't. Well, Glanville, how do you know we weren't? Because all we were doing was defining immunity and telling Woody about immunity. So that is what he's saying, y'all. He's saying that this was just legal definitions. Okay? This was just explaining to Woody what immunity is and the consequences thereof. Okay? So let's see. Earth Angel, any witness valuable enough for immunity must be a critical phase. Look, again, I'm explaining what Glanville is saying. So y'all, of course, I'm gonna have to keep saying this because I don't want people getting mad at me. Right? But at least you can. Okay. All right. Let's pause, y'all. Let's pause for a second because we have to go to the third point, which is really the second point here in the middle. But let's pause for a second. Emergency. Okay. The third point